So in chapter 4, we're going to see a brief report of the consultations that took place in the Quebec region, including the preparations and complementary approaches. And in this first slide, you will take into consideration the topics that will be discussed, running from March 13, 2013 to June 27, 2013. Starting March 13, 2013, the topic, there's a meeting with the AFNQL chiefs held at Kiuna College, and the topic of education as well as the proposed new legislation are central to the meeting. During this meeting, the chiefs decided to go along with the process and to develop a strategy. The FNEC drafted a document entitled Quality Education for All First Nations Citizens for the Chiefs' consideration. As well, during that meeting, the FNEC presented a critical analysis of AANDC's discussion guide, and lawyer Zach Davis from the firm Hutchins Legal presented his legal opinion upon request from the FNEC. A discussion followed this meeting. On March 13, also on the same day during that meeting at Kiuna, following this discussion, it was decided that it was up to every council to decide who would participate and to name a representative in view of the March 26 consultation. It was also decided that a declaration would be read by Regional Chief Ghislain Picard, and that the legal opinion from lawyer Zach Davis would be sent to all First Nations Council. Upon conclusion of the meeting, the chiefs decided to hold a preparatory meeting the day before the official consultation meeting. The consultation meeting to take place on March 27 and the preparatory meeting to take place on March 26. So between March 13 and 26, much work has been accomplished by the FNEC, including the drafting of the declaration to be read by Chief Ghislain Picard. In view of the March 26 meeting, the evening of the consultation, the meeting with the AFNQL chiefs is taking place in Wendake, and the chiefs agreed on the following procedure for the next day. After the opening ceremony, the chief of the AFNQL will take the floor to read the political declaration prepared for this meeting by lawyer Zach Davis and with the FNEC. The documents would be presented to AANDC's representative, and Chief Picard would declare an end to the consultation meeting. The documents to be handed out, other than the political declaration, is the legal opinion on the process by Zach Davis, and a document entitled Quality Education for All First Nations Citizens by the FNEC. Another document by Sakapesh entitled To Take Real Responsibility of Education is also scheduled to be presented. On the day of the consultation, March 27, 2013, meeting to be held with AANDC's representative in Wendake. Everything goes according to what the chiefs agreed upon the day before, but AANDC representatives offered to pursue the meeting after the reading of the political declaration and delivery of documents by the regional chief of the AFNQL, but as previously agreed upon, the chiefs refused to pursue discussions with AANDC. The legal opinion presented specifies that the consultation process does not meet the federal government's obligation to consult and accommodate and list all the shortcomings. So logically speaking, the next step will be for AANDC's representatives to read the opinion and respond to it. AANDC representatives are also expected to read the other documents delivered and also respond to them. It is also hoped that AANDC's representatives will take into account all documents handed. So this clarifies what took place on March 26 and 27, and now we will see a 15-minute presentation of the legal opinion by and with lawyer Zachary Davis from the firm Hutchins Legal in Montreal.
Hello, my name is Zachary Davis. I am a lawyer with Hutchins Legal Inc. in Montreal, and I've been working regarding the consultation process leading up to the proposed First Nation Education Act for the First Nations Education Council. I will be presenting a legal opinion on the consultation process and on whether the consultation process proposed by the federal government is sufficient to discharge its constitutional duties. In December 2012, the federal government announced that it was beginning a consultation process for the development of a First Nations Education Act, federal legislation to govern the provision of First Nations education. The present opinion evaluates whether the proposed consultation process is sufficient to discharge the Crown's constitutional obligation to consult First Nations in the circumstances. Our conclusion is that the consultation process and the proposed legislation fall short of fulfilling the Crown's duty to consult First Nations as is required. More specific recommendations regarding what could be done to improve this are set out at the end of this opinion. The first question that we must ask in the circumstances is whether a duty to consult arises with respect to legislative action taken by the federal government. Where the Crown is contemplating a course of action or decision that could have a negative effect on established or asserted Aboriginal rights, it must consult with the relevant Aboriginal groups and, if appropriate, seek to achieve a reasonable accommodation of the Aboriginal rights at issue. The Crown conduct being contemplated here, obviously, is the development of legislation governing First Nations education. The Supreme Court of Canada has left unanswered the question of whether or not legislative action triggers the duty to consult. But two cases from the Alberta Court of Appeal have addressed the issue. The first, R versus Left Hand, found that there can be no duty to consult prior to the passage of legislation, even where Aboriginal rights will be effective, and that it cannot be suggested that there are any limits on Parliament's power to amend the Indian Act. However, just 3 years later, the same court, the Alberta Court of Appeal, found the following in the Tsuut'ina Nation case. Even if the legislature itself does not have a duty to consult prior to passing legislative action, the duty may still fall upon those assigned the task of developing the policy behind the legislation, or upon those who are charged with making recommendations concerning future policies and actions. Given that this is the leading word of the Canadian courts on the question of whether or not the duty to consult falls on the federal Crown or on the Crown in general when undertaking legislative action, we can conclude that to the extent that the Crown's contemplated education policy might adversely affect Aboriginal rights, the Crown owes First Nations a duty to consult regarding the contemplated First Nations Education Act. The next issue, and this is the third slide of the presentation, is the depth of the Crown's duty to consult in the circumstances. The scope and extent of the Crown's duty to consult depends on the strength of the case supporting the existence of Aboriginal rights in question and the seriousness of the potential adverse effect upon those rights. For this reason, the duty to consult is best thought of on a spectrum, with content determined in specific circumstances. Deep consultation is required where the rights at play are well established and the rights and their potential infringement are of high significance to the Aboriginal people involved, and the risk of non-compensable damage is high. The First Nations Education Act could reshape how First Nations children are educated by setting mandatory standards, practices, curricula, and governance structures. Some First Nations might feel that the regime set out in the First Nation Education Act conflicts with their preferred means of delivering education services. A regulation that denies Aboriginal rights holders their preferred means of exercising their rights is a prima facie infringement upon those rights. Therefore, the first question that we need to ask when evaluating the depth of the Crown's duty to consult in the circumstances is what is the strength of the right claimed by the First Nation? That is, what is the strength of First Nations' assertions to right of self-government and self-determination with respect to education? First Nations hold an inherent right to exercise jurisdiction over education as an aspect of the Aboriginal right to self-government and self-determination. These are existing Aboriginal rights protected by Section 35 of the Constitution Act 1982, which has been recognized by Canada. The Aboriginal right to self-government, as was expressed by the Supreme Court of British Columbia in the Campbell case, is akin to a legislative power to make laws, and has survived as one of the unwritten underlying values of the Constitution outside of the powers distributed to the federal Parliament and to provincial legislatures. Aboriginal rights continue to exist as one of three distinct orders of government in Canada: Aboriginal, provincial, and federal. Education is a key element of self-government and self-determination, and this has, among other places, been recognized in international law by the United Nations Declarations on the Rights of Indigenous Peoples, in which it is written that Aboriginal people, Indigenous people, have the right to establish and control their education systems and institutions in their own languages in a manner appropriate to their cultural methods of teaching and learning. This is essential, obviously, because education is the instrument through which cultures perpetuate themselves. Now, turning to the fifth slide in the presentation, I want to make the point that First Nations powers over education, the power to control the education of their community members outside of federal legislation, has already been recognized by Canadian courts, and in particular by the Manitoba Court of Appeal in the Chatty case, in which it was written that although the Indian Act does give the federal government some powers over First Nations education, local First Nations are free to make their own arrangements for facilities and staff to provide a suitable education program for their children, and in doing so, the Band Council is not under the direct supervision of the minister. With this background, we can conclude that any further federal legislation that would regulate or restrict the exercise of this authority, of the authority over education held by First Nations, or that would make it subject to federal oversight, would be a prima facie infringement of the Aboriginal right to self-government and self-determination. The proposed First Nations Education Act, therefore, would inevitably affect the exercise of this right. Therefore, by contemplating the creation of the Act, the Crown has triggered a duty of deep consultation. It being established that the Crown owes a duty to consult in the circumstance, and that duty to consult is a profound one, what is left to be done, and this will be the remainder of this presentation, is to evaluate what specific duties the Crown has and owes to First Nations in the circumstances, and whether the proposed consultation process is sufficient to meet those duties. So the sixth slide of the presentation addresses the first issue, which is the timing of consultation. The Crown is required to notify Aboriginal peoples when it is contemplating a course of conduct or a decision that might negatively affect their rights or interests. And this is when consultation begins. The Crown must initiate consultation early, before its decision-making process is complete, and First Nations must be given reasonable time to respond to notices and referrals for consultation. The launch of consultations, as I mentioned at the beginning, began in December 2012. According to the plan laid out at that time, First Nations would be provided, given the opportunity to provide input on the contents of the proposed legislation until April 2013. Only one day of consultations was scheduled to be held in each province, with only one day held in Quebec, and that was on March 27th. Given the importance and the complexity of this file, the deadline of April 13th was likely insufficient to allow First Nations time to properly prepare a position on the matter of how education legislation should move forward, if at all. And in particular, one day of consultations would have been insufficient to fully go through an in-depth consultation process on all of the issues at play. In Phase 2 of the proposed consultation process, draft legislation will be shared with First Nations from across the country for feedback. It is critical at that phase that appropriate First Nations groups and representatives are given enough time to review the draft and that their feedback be taken seriously by the federal government. Acknowledgements of First Nations concerns by federal officials absent any commitment to reflect those concerns in draft legislation would not be sufficient to discharge the Crown's duty to consult. Appropriate First Nations groups and representatives should also be given a chance to review and comment on the final version of legislation, both before the bill is tabled in Parliament and as it goes through the parliamentary process. The next issue that arises in the consultation process, and this is the seventh slide of the presentation, is the need for the federal government to acknowledge First Nations rights with respect to education. The Crown must formally consider the seriousness of claimed rights put forward by affected Aboriginal groups and the impact of the potential infringement. That is and should be the first step in discharging the duty to consult. The Crown's preliminary assessment of the strength of the claim and the potential adverse effect of government action on Aboriginal interests must be made at the outset of the proposed consultation, if it is to inform the scope and extent of the process, and that's common sense. This step is absent from the consultation documentation. Nowhere does the discussion guide mention First Nations' right to self-government or to self-determination, except to say that the new legislation will not apply to First Nations who are already self-governing and have laws with respect to education. But by that, we understand that they are referring only to those First Nations that have signed self-government agreements, which excludes the vast majority of First Nations in Canada. This fails to acknowledge the critical place that control over education as a key element of cultural reproduction plays in the effective expression of First Nations self-determination. Without acknowledging First Nations' rights to self-government and self-determination and their inherent jurisdiction over education, the consultation process and the subsequent legislation are doomed to falter. They are doomed to fall short of what is required to accommodate the asserted right. The federal government must take into account and respect First Nations jurisdiction over education. The First Nations Education Act and the consultation process leading to it must acknowledge and accommodate this jurisdiction. The next issue, addressed on the 8th slide of the presentation, is the need for the federal government to consult the right group. The duty to consult is owed to First Nations communities as a whole, which hold rights collectively as a whole. It is not due to individuals or to certain representative organizations that are themselves not rights holders. When consultations involve communal rights of fundamental importance, the best approach is for First Nations to agree internally on who will speak for them, and for the Crown to respect the position taken by First Nations and engage with them at the level that First Nations request. Thus far, the Crown has indicated that the first stage of consultation will involve engaging with First Nations parents, educators, leaders, and other invited participants. During the second stage, draft legislation will be sent to First Nations chiefs across the country for comment. The flaw in this approach is that it appears that Canada is selecting the individuals and groups with whom it will consult, as opposed to respecting First Nations' decision regarding who should speak for them. First Nations ought to be determining who Canada will consult, and Canada ought to respect their decision. It should be noted that the Crown's unilateral move to begin consultations and the short time frame that it imposed for the consultation process has made this difficult, if not unworkable. The next requirement is the requirement of good faith. At all stages of consultation, good faith is required on both sides. The Crown must intend to substantially address First Nations concerns. If during the consultation process leading to the proposed legislation, the Crown or its representatives engage in sharp bargaining, negotiate with an oblique motive or an alternate agenda, or otherwise negotiate in bad faith, then this course of conduct could amount to a breach of the duty to consult. And this kind of action could be reviewable even if the Crown comes to no final decision regarding First Nations legislation with respect to education. However, it's important to understand that the Crown is not bound by a duty to agree. It is only bound to engage in a meaningful process with the intention of substantially addressing First Nations concerns. If, however, the Crown chose to include certain elements in the First Nations Education Act that infringe on First Nations rights, those infringements must be justifiable. And most importantly, if national legislation regarding First Nations education is going to work, it must have First Nations support. If it is imposed against First Nations' will, and in light of First Nations protests, it is difficult to understand how the plan could lead to better education. The next issue, and this was raised in the discussion of good faith, is the need for the Crown to address First Nations concerns. This is slide 10 of the presentation. Whether the Crown's duty to consult a First Nation lies at the low or the high end of the spectrum, the Crown must consult with the goal of substantially addressing First Nations concerns. It is our understanding that the Crown has not developed a formal method for review and considering submissions during the consultation process. This raises a red flag. How can First Nations know that their concerns will be seriously addressed if they do not know how their concerns will be considered after consultations are finished? If possible, First Nations should be involved in developing a methodology for reviewing submissions made during consultations, before any further consultations proceed. At the very least, to ensure the seriousness of the consultation process and of the consideration that the Crown will give to the consultations, First Nations representatives should insist that all submissions made during the consultation process be made public, so that they can compare the submissions to the final result. And where a deep level of consultation is required, as here, the Crown can be obliged to provide First Nations with written reasons to show that their concerns were considered and explain how they impacted the decision and the course of action that was eventually chosen. This should be insisted on in the circumstances for at least two reasons. First, it will help to ensure that submissions made by First Nations are seriously considered. And second, if the Crown ultimately chooses a course of action that certain First Nations find unacceptable, the written reasons would provide a basis for deciding whether or not to engage in court action to challenge the proposed legislation. So, given that review of the Crown's obligations stemming from the duty to consult, the strength of the First Nations' claim to a right to self-government and self-determination with respect to education, and the potential infringement of the proposed plan, we can conclude, as was evident from the analysis, that certain elements in the proposed consultation process fall far short of what is required by the honor of the Crown. In the circumstances, we recommend that the following action be taken in order to ensure that the consultation process meets the Crown's obligations. Where First Nations present a well-documented and justified request for an extension to the April 2013 deadline to provide input on the proposed legislation, the Crown should grant that request. Where more than 1 day is required for consultations, First Nations should present a well-documented and justified request for further sessions, and the Crown should grant that request. To the extent possible, First Nations ought to determine internally who Canada will consult, and Canada ought to respect their decision. Canada and First Nations should cooperate in developing a methodology for assessing and addressing submissions made during consultations. All submissions made during consultations should be made public. When draft legislation is produced, the Crown ought to provide written reasons to show that First Nations concerns raised during consultations were considered and to explain how they impacted the draft text. And a meaningful consultation must continue after draft legislation is produced and throughout the legislative process. And on a final note, First Nations must be given sufficient financial resources to meaningfully participate in the consultation process. Otherwise, the consultations or any negotiation of eventual legislation will be lopsided, and there is a serious risk that the honor of the Crown will not be upheld and that First Nations concerns will not be properly considered. In terms of the adequacy of the consultation process leading up to the development of a First Nations Education Act, a question has often come up, and we've come to think of it as the question of the catch-22. On the one hand, First Nations are obliged to participate in the consultation process in good faith. On the other hand, First Nations, quite rightly, often have little faith that what they bring to the consultation process will be considered, and that if they show up at the consultation process, they will be told that they were consulted and that the Crown has met its constitutional obligations. The issue then is how to avoid the catch-22, how to participate in the consultation process in a meaningful way and in a productive way. And the answer that I would give to that question is that in thinking about whether or not the duty to consult was met, it's important not to think of the duty to consult as an on or an off issue, as a black or a white issue. Rather, instead of asking whether the Crown consulted or not, First Nations should ask whether the consultations were sufficient or not. So First Nations have an obligation to engage in the consultation process in good faith. But the Crown has an obligation to take First Nations concerns seriously. So First Nations that engage in the consultation process should clearly articulate what it is that they want, what it is that they're looking for from the Crown, and should document their articulation of these points, and should try to hold the Crown to account to meet their minimum criteria. If the Crown does not meet their minimum criteria, then the argument can be made that the Crown failed in its duty to consult, not because it didn't consult, but because the consultations were insufficient.
Consequently, following the meeting on March 27, we are now April 24th. Following the meeting of March 27, the documents and declaration presented to AANDC, as well as the legal opinion by Zachary Davis and the complementary activities as well in respect of the new legislation. The chiefs on April 24th, the chief of the AFNQL met with AANDC Minister Bernard Valcourt. The discussion centered on the minister who agreed upon continuing to examine Quebec's position on a future Education Act. However, there was no official minutes of this meeting. So what came out of the meeting is that the minister commits to fully consider the documents presented on March 27th, which is the legal opinion and the other documents. Now we are April 24th, and Minister Valcourt still didn't read the documents and political position of Quebec. On May 20th, the regional AFNQL chief and an FNEC delegation met with James Anaya, United Nations Special Rapporteur. The proposed Canadian government's education legislation is being discussed, as well as the infringement on First Nations rights. Mr. Anaya is presented with the documents that were presented to AANDC on March 27, as well as the following correspondences to Deputy Minister Wernick and Minister Valcourt. We'd like to specify, we feel that Mr. Anaya had well felt interest on the topic and mentioned that he was greatly concerned by this issue and that the file that we presented him with would be useful on an upcoming visit to Canada planned for the fall. During that meeting, the meeting also served to provide further clarification and notes that the Special Rapporteur had read in the documents sent earlier. Along with the AFNQL, the FNEC will agreed to keep the Special Rapporteur updated with information on the latest developments regarding the new legislation. As well, an invitation to Quebec was extended to him and the AFNQL, as well as the FNEC. It was agreed upon that the AFNQL and the FNEC would help him plan his stay in Quebec during his upcoming visit to Canada, as mentioned, scheduled for fall. On May 21st, 2013, at the UN Permanent Forum on Indigenous Issues, the chief of the AFNQL submitted a joint declaration with the FNEC recommending that the Permanent Forum takes measures to ensure that the United Nations Declaration on the Rights of Indigenous People is honored nationwide. And you will find in reference at the URL link a press release in reference to the declaration. As well, the full text of the declaration can be found under the FNEC's website. So in a nutshell, between April and June 2013, several letters were then exchanged between Deputy Minister Wernick, Minister Valcourt, and the Chief of the AFNQL, Ghislain Picard. So the Deputy Minister and Minister expressed their disappointment and directed some blame at position adopted by the AFNQL chiefs and hoped that the consultation would resume. As per Chief Ghislain Picard maintained that none of their letter addressed the issue raised during the March 27th presentation by the legal opinion, and he reiterated this request. On June 27th, a letter was sent to Minister Valcourt regarding minimal conditions. The letter states that the federal government continuously refers to First Nations as willing or interested partners without giving a clear definition on what is a willing partner. Oftentimes, the federal government will use the expression willing partners in their correspondence when it is really not the case. So the chief of the AFNQL indicates that First Nations are also willing to do business with a government that is a willing partner, and he specified the conditions to this end. Presented in this form, the chief of the AFNQL follows up on repeated efforts by the FNEC to confront the federal government on its positions related to certain unavoidable issues for First Nations. So here is an excerpt of the correspondence on minimal conditions that I will read to you. We are also aware that the federal government constantly reiterates its readiness to work with willing partners in developing the First Nations Education Act, and this raises serious questions. The basis or criteria by which your government considers First Nations to be willing partners has never been specified. The term willing partners remains ambiguous. Application of the term appears to be limited to or reserved for those First Nations that accept conditions decided by, if not simply imposed by, the federal government. Accordingly, we ask that you specify which criteria or conditions the federal government used to determine if First Nations are willing partners. Still to this day, we haven't received feedback on the definition of what are willing partners in the federal government's view. Another excerpt from that letter, on which we insist upon because we consider it to be a very important letter, reads as follows. As First Nations, we are also interested in collaborating with a government that commits to act as a willing partner, and we have started specifying certain conditions that would demonstrate such commitment. What follows are the preliminary results of this exercise. A government, in order to qualify as a willing partner, should commit to at least the following: adequate financing of First Nations education, upholding First Nations rights, inherent rights, treaty rights, and international law, and adopting measures to foster the full expression of these rights. Implementation of the UN Declaration on the Rights of Indigenous Peoples, in particular requiring the free, prior, and informed consent of First Nations on any state measures or initiatives that would impact First Nations rights. Recognition and respect for First Nations control of First Nations education, 2010. A treaty-based and nation-to-nation discussion on educational matters. Adequate support and recognition of the right to language and culture. Recognition and respect for First Nations diversity and existing education systems. So in essence, that were the main points of the letter sent to Minister Valcourt, which is very important because it requires not only the government to define its criteria, but also responds to the criteria we have established to consider them as willing partners.